Hello and welcome. My name is Kirsten Whitfield. I'm a Director in Fieldfisher's Privacy, Security and Information Law team, and I'm joined by Beresford, who is a solicitor in our team. And today we're going to be talking about binding corporate rules. This is part of our Get Data Protection Fit series. And we're now on to Module 3, where we're talking about cross-border issues and data transfers. And this is segment 2 of Module 3. We're talking today about binding corporate rules projects, why and how you should do them. In this session, we're going to have a recap of the GDPR transfer mechanisms for transferring personal data outside of the European Economic Area. We'll take a look at what BCRs actually are, so that's binding corporate rules, the pros and cons of BCRs, and what the application process involves. So by the end of this session, you'll be able to better understand what a BCR is, the pros and cons of using BCRs, and have a good overview of the BCR application process. So at this point, I will hand over to Alex.
Thanks, Kirsten. Now, if you have been following our Get Data Protection Fit series, you will remember our final session of Module 1 gave an overview of international data transfers. Before we take a closer look at BCRs in particular, it's good to recap on the overall picture for data transfers and how BCRs fit in. So, you may remember from Module 1 of Webinar 6, the general position is that within the EEA, personal data should be able to flow freely. It can also flow freely to countries outside the EEA, where the European Commission has designated that country as providing an adequate level of protection for personal data. This includes countries like Switzerland, Uruguay, and New Zealand. But outside these adequate countries, what we would call a restricted transfer, it is not possible to do this unless an approved mechanism to allow the transfer under GDPR is in place. Now, the various approved mechanisms are listed on the slide here, but due to the recent Schrems II decision, the EU-US Privacy Shield has now been invalidated, and furthermore, the Code of Conduct and certifications are not yet in existence. So this actually leaves us with the options in green. Now, SCCs were dealt with in the webinar just before this one, but to recap, these have now been further complicated by the Schrems II decision, as although not deemed invalid, further additional measures are needed to ensure an appropriate level of protection. Do take a look back on our webinar on SCCs in this module for more information. For now, the Swiss-US Privacy Shield and BCRs have not been directly impacted by Schrems, because it only looked at the EU-US Privacy Shield and SCCs. But just because they did not mention them doesn't mean it's safe to assume that the additional measures won't apply to these too. And just to complete the picture on international data transfers, we then also have the derogations under GDPR. These include things like explicit consent of the data subject and performance of a contract. But remember, these are not intended to apply to large-scale transfers. They're really for use in one-off ad hoc transfers, and they will apply in very limited situations. The explicit consent derogation, for example, will generally not be able to be relied on in an employer-employee context, as it's difficult to say that the consent is freely given due to the imbalance of powers between the parties. So, moving on to look at BCRs in a bit more detail. What are BCRs? Well, BCRs, or binding corporate rules, are generally referred to as the gold standard of transfer mechanisms because they are a regulated concept and regulator approved, but now also officially recognised by GDPR. Essentially, they are a big series of legally binding documents and contracts which govern transfers of personal data outside the EEA within a group of companies. These documents, in the same way as SCCs or model clauses, confer rights on data subjects, but they are also submitted to a competent data protection authority and the European Data Protection Board for approval. Now, there's two types of BCRs, those dealing with controller transfers and those dealing with processor transfers. The GDPR helpfully sets out what should be included in your BCR policy, and the European Data Protection Board, who we call the EDPB, also have various checklists which you can use to ensure everything has been covered in your BCR application. The way BCRs usually work is that you have a front-end policy, controller policy, processor policy, and then you have various appendices. The purple highlighted examples on the slide are typically what we would include in these appendices. Then you have the intra-group agreement, which everyone becomes party to and where each entity promises to comply with the controller or processor policy, or both. Although do note the intra-group agreement is just one mechanism to make sure the documents are binding. This is the way Fieldfisher clients usually do it, but there are other ways to make the documents binding. The EDPB has helpfully produced lots of guidance on what to include in the application and in the policies and the process for BCRs generally. So if you are considering this transfer mechanism, this would definitely be a good starting point, and we will include a link to this on our last slide.
Thanks, Alex. So why might you consider putting a BCR in place? Well, probably top billing is that it's generally considered the gold standard in the European Union for data transfers. It's a pretty involved process, and you'll get to know your lead data protection authority pretty well. So in that sense, it's also good for building a relationship with your lead data protection authority. Another advantage is that it does provide an entire compliance framework. So it's really the tracks for the train to follow, which really helps keep your compliance on track and avoid it getting derailed. It's widely recognised by many non-European Union territories as well, which is a bonus. Now, because it's considered the gold standard for data transfers, and customers will typically know that it does involve quite an involved process of assessment by a regulator, it's also really good for good PR and gaining customer confidence in your privacy practices. In the long term, the downside is that it can take a while and be quite burdensome to put in place, but weighed against that is the advantage that it can actually be quite a big burden to put lots of sets of standard contractual clauses in place as well, either within the group or if you're a processor and you've got all of your customers that want standard contractual clauses in place that you have to negotiate and you have to keep them up to date. That actually can take up a lot of time and resource in the long term. The other good thing about BCRs is that there is a lot of flexibility to add and remove group entities to it. So, as with standard contractual clauses, there could be actually quite a burden in terms of keeping those up to date, including where data is transferred to or not. It's much easier to update your binding corporate rules once they're in place by adding group entities to it, or group entities might drop out of the BCR. And then typically what you would do is you do an annual update to your lead data protection authority. It could also be helpful from a post Schrems 2 fallout perspective. So as we heard earlier, there's standard contractual clauses. They are still standing and they're valid as a mechanism that you can use. But you would be expected potentially to do other things on top of the standard contractual clauses for some countries that the data might be transferred to. So, for some, the binding corporate rules may give more comfort, although what I would say is that some regulators, like in Germany, for example, have actually said that binding corporate rules are not immune from the Schrems 2 fallout. So essentially you may well need to do the same type of additional measures. So what are the disadvantages of a BCR? Well, there's no denying it will be time consuming, and it can be an expensive solution initially, both from a resource and a cost perspective. It can also take quite a while to implement, so certainly at the moment what we're seeing is that there's probably an 18-month minimum turnaround time period to get your binding corporate rules in place. And there can be quite a lot of variance in terms of your experience of getting your BCR in place, depending on which lead data protection authority you might be using. And the authorities themselves, some have more experience than others. And another downside is that it's not like Privacy Shield as it was, where that was a self-certification. Binding corporate rules does involve a lot of scrutiny by data protection regulators in Europe. So, just to give you a bit of an overview of what that scrutiny looks like. Well, you start with your lead authority that will review your BCR. So this is the authority that's going to be sort of overseeing your BCRs. And once the lead authority has reviewed and approved your BCR, which may take a few rounds of comments and back to and forth with the lead authority, it would then go to co-reviewers. So these are a couple of other countries which are key countries for you and your BCR that will review in detail and comment on your BCR, and you then address those comments. And then once that is done, the BCR will go out to other data protection authorities in Europe, generally for them to have a look at the BCR and make comments if they want to. And then finally, if you don't get comments back, or you do get some comments and you've addressed those comments from the other concerned data protection authorities, it goes to the European Data Protection Board, who review and again may well comment, and you may need to address some comments there. But having done that, you then get to the end point where you get the seal of approval from the European Data Protection Board for your binding corporate rules. So, some key takeaways from Module 3. Hopefully now you have a better understanding of what binding corporate rules are, the pros and cons of using binding corporate rules, and you have an overview of what the BCR application process looks like. Now, if you have any questions about binding corporate rules, please do get in touch with us. So you've got Alex's and my contact details here, and we've also given you some links on this page to useful information. So there's our Fieldfisher privacy blog, which is a really excellent way of keeping up to speed with privacy developments. There's Fieldfisher's privacy YouTube page, where you get all of these great training sessions from our Data Protection Fit series, but also other webinars on there. And we've also given you a link to the European Data Protection Board's guidance on binding corporate rules, where, as Alex mentioned earlier, you'll find lots of useful guidance on making your BCR application. Thank you for listening.